Question 1. Market research demonstrates that clients often struggle to grasp the intricacies of option valuation. When discussing options with a client, which of the following approaches best aligns with the principles of suitability and clear client communication as required by the Series 66 exam? Option A. Provide a simplified analogy of a lottery ticket to illustrate the potential for a large payout with a small initial investment, without detailing the underlying valuation mechanics. Option B. Present a complex mathematical formula for calculating theoretical option prices and instruct the client to use it to determine their own investment decisions. Option C. Explain that an option's value is determined by several key factors, including the price of the underlying asset, the time remaining until expiration, the expected volatility of the underlying asset, and prevailing interest rates, and how changes in these factors can impact potential gains or losses. Option D. Emphasize the potential for unlimited profits and minimal losses, suggesting that options are a highly speculative tool for quick wealth accumulation. The correct answer is C. Explain that an option's value is determined by several key factors, including the price of the underlying asset, the time remaining until expiration, the expected volatility of the underlying asset, and prevailing interest rates, and how changes in these factors can impact potential gains or losses. Explanation. This scenario is professionally challenging because it requires a financial professional to advise a client on complex financial instruments, specifically options, without resorting to simplistic or misleading explanations. The challenge lies in conveying the inherent risks and potential outcomes of option valuation in a manner that is both accurate and understandable to a client who may not have a sophisticated financial background. The Series 66 exam emphasizes the importance of suitability and clear communication, ensuring that clients understand the products they are investing in. The correct approach involves explaining option valuation conceptually, focusing on the factors that influence an option's price and its potential for profit or loss, without requiring the client to perform calculations. This aligns with regulatory requirements under the Uniform Securities Act, which mandates that investment recommendations be suitable for the client's investment objectives, financial situation, and risk tolerance. Explaining that an option's value is influenced by underlying asset price, time to expiration, volatility, and interest rates, and how these factors can lead to gains or losses, provides a foundational understanding without overwhelming the client with complex mathematical models. This approach prioritizes client education and informed decision-making, which is a cornerstone of ethical conduct and regulatory compliance. An incorrect approach would be to focus solely on the potential for high returns, without adequately explaining the associated risks of losing the entire premium paid. This misrepresents the nature of options and violates the duty to provide a fair and balanced presentation of investment products. Another incorrect approach would be to present a simplified, potentially misleading, analogy that does not accurately reflect the complexities of option pricing and risk. This could lead to a client making investment decisions based on flawed understanding, which is a failure of due diligence and a potential violation of suitability rules. Finally, an approach that involves providing specific price targets or profit projections without a clear and justifiable basis, or without emphasizing the speculative nature of such predictions, would be considered unethical and potentially fraudulent. Professionals should approach this situation by first understanding the client's financial goals, risk tolerance, and existing knowledge of financial markets. They should then explain option valuation in clear, non-technical terms, using conceptual examples to illustrate how changes in market conditions affect an option's price and potential outcomes. The focus should always be on educating the client about the risks and rewards, ensuring they can make an informed decision that aligns with their personal circumstances. Question 2. Analysis of an investment advisor's interaction with a new client reveals that the client, who has expressed a desire for aggressive growth, specifically requests that their entire portfolio be invested in a single, highly volatile technology stock that has recently experienced significant price fluctuations. The advisor has conducted initial due diligence on the client's financial situation, risk tolerance, and investment objectives, which indicate a moderate risk tolerance and a long-term investment horizon. What is the most appropriate course of action for the investment advisor in this situation? Option A. Advise the client that their request is inappropriate and refuse to manage their account if they insist on this investment strategy. Option B. Immediately invest the client's entire portfolio in the requested single technology stock, as the client has explicitly directed the investment. Option C. Recommend a diversified portfolio that includes a mix of asset classes and securities, explaining how it aligns with the client's stated objectives and moderate risk tolerance, while also addressing the risks associated with the client's requested single stock. Option D. Invest a small portion of the client's portfolio in the requested stock, while allocating the remainder to conservative, low-yield investments to satisfy the client's request while mitigating risk. The correct answer is C. Recommend a diversified portfolio that includes a mix of asset classes and securities, explaining how it aligns with the client's stated objectives and moderate risk tolerance, while also addressing the risks associated with the client's requested single stock. Explanation. This scenario presents a professional challenge because it requires an investment advisor to balance a client's stated preference with the advisor's fiduciary duty to act in the client's best interest, particularly when the client's preference may lead to suboptimal outcomes or expose them to undue risk. The advisor must navigate potential conflicts of interest and ensure full disclosure. The correct approach involves the investment advisor thoroughly researching and understanding the client's financial goals, risk tolerance, and time horizon. Following this, the advisor must present a diversified portfolio recommendation that aligns with these factors, clearly explaining the rationale behind the proposed investments and any associated risks. This approach is correct because it directly fulfills the advisor's fiduciary duty under the Investment Advisors Act of 1940 and relevant state securities laws, which mandate acting with the utmost good faith and in the client's best interest. It also adheres to the principles of suitability, ensuring that recommendations are appropriate for the client's circumstances. An incorrect approach would be to immediately implement the client's request for a single, highly speculative stock without further due diligence. This fails the fiduciary duty by prioritizing the client's potentially ill-informed directive over the advisor's professional judgment and obligation to recommend suitable investments. It also violates suitability standards, as a single speculative stock is unlikely to be appropriate for most investors seeking long-term financial security. Another incorrect approach would be to dismiss the client's request outright without discussion or explanation. While the advisor may believe the request is unsuitable, failing to engage with the client, understand their reasoning, and educate them on alternatives demonstrates poor client service and a lack of adherence to the principle of open communication and transparency, which are crucial for maintaining trust and fulfilling advisory responsibilities. A further incorrect approach would be to recommend the speculative stock, but heavily emphasize its potential for rapid gains while downplaying or omitting the significant risks involved. This constitutes a failure in full and fair disclosure, a core ethical and regulatory requirement. The advisor must present a balanced view of potential rewards and risks, not selectively highlight favorable aspects to persuade the client. The professional decision-making process for similar situations should involve a structured approach. First, actively listen to and understand the client's request and underlying motivations. Second, conduct thorough due diligence on the requested investment and assess its suitability against the client's established financial profile. Third, if the request is deemed unsuitable, clearly and professionally explain the reasons why, referencing relevant risks and alternative strategies that better align with the client's goals. Fourth, present a well-researched, diversified, and suitable recommendation, ensuring all potential benefits and risks are transparently communicated. Finally, document all discussions, recommendations, and client decisions. Question 3. Cost-benefit analysis shows that a new client could benefit from a more aggressive investment strategy, potentially leading to higher returns. The investment advisor representative IR is considering structuring their compensation as a performance-based fee. Which of the following approaches to performance-based fees would be most compliant with the Investment Advisors Act of 1940 and its rules, assuming the client meets the necessary criteria for such fees? Option A fee based on a percentage of the net capital gains or appreciation of the managed account over a specified annual period, benchmarked against a recognized market index. Option B, a fee that increases the percentage of assets under management if the account's value exceeds a certain threshold by year-end, without specific reference to capital gains. Option C, a fee calculated as a percentage of the gross unrealized appreciation of the portfolio. Option D, a fee based on the total return of the account, regardless of market conditions or the client's overall financial goals. Correct answer is a fee based on a percentage of the net capital gains or appreciation of the managed account over a specified annual period, benchmarked against a recognized market index. Explanation: this scenario presents a professional challenge because it requires an investment advisor representative IR to balance the potential for increased compensation with the fiduciary duty owed to clients. The temptation to structure fees in a way that maximizes the advisor's income, even if not the most advantageous for the client, is a significant ethical pitfall. Careful judgment is required to ensure that any fee structure aligns with the client's best interests and complies with regulatory requirements. The correct approach involves structuring performance-based fees in a manner that is permissible under the Investment Advisors Act of 1940 and its associated rules, specifically Rule 205-3. This rule permits performance-based fees for certain clients, typically qualified purchasers or registered investment companies, provided that the fee is based on a percentage of the capital gains or capital appreciation of a managed account. Crucially, the fee must be based on the net capital gains or appreciation of the account over a specified period, and the benchmark used must be disclosed. The advisor must also ensure that the fee structure does not incentivize excessive risk-taking or trading. This approach upholds the fiduciary duty by ensuring that the performance metric is directly tied to the client's investment success and is transparent. An incorrect approach would be to charge a performance fee based on the total return of the account, without accounting for market fluctuations or the client's overall financial goals. This could incentivize the advisor to take on undue risk to generate higher returns, potentially harming the client. Such a fee structure would likely violate the spirit and letter of Rule 205-3 by not being tied to net capital gains or appreciation, and could be deemed an undisclosed conflict of interest. Another incorrect approach would be to charge a performance fee based on a percentage of assets under management, AUM, that increases significantly if certain arbitrary performance thresholds are met, without those thresholds being clearly defined as capital gains or appreciation. This is essentially a tiered AUM fee disguised as performance-based compensation and does not align with the regulatory intent of performance fees, which is to reward actual investment gains. It creates a conflict of interest where the advisor might focus on gathering assets rather than generating superior investment performance. A third incorrect approach would be to charge a performance fee that is calculated on a gross basis for deducting client-specific expenses or taxes. Rule 205-3 requires performance fees to be based on net capital gains or appreciation. Charging on a gross basis would overstate the client's actual gains and lead to an inflated fee, which is both unethical and a violation of the rule. The professional reasoning process for such situations should begin with a thorough understanding of the client's investment objectives, risk tolerance, and financial situation. Then, the advisor must consult the relevant regulations, particularly Rule 205-3, to determine permissible fee structures. Any proposed performance-based fee must be clearly explained to the client, including the benchmark, the calculation methodology, and any associated risks. Transparency and a clear demonstration that the fee structure is in the client's best interest are paramount. If there is any doubt about the compliance or ethical implications of a fee structure, the advisor should seek guidance from legal counsel or compliance departments. Question 4. Process analysis reveals that a company is planning to offer its securities directly to a limited number of accredited investors in a transaction that appears to qualify for an exemption from registration under the Securities Act of 1933. During the offering process, the company's CEO makes several optimistic but unsubstantiated projections about future earnings to encourage investment. Which of the following best describes the regulatory implication of the CEO's statements in this scenario? Option A. The statements are a violation of the anti-fraud provisions of the Securities Exchange Act of 1934, even though the offering is exempt from registration. Option B. The statements are permissible because the company is selling directly to investors, not through a broker-dealer. Option C. The statements are permissible because the offering is exempt from registration and the investors are accredited. Option D. The statements are permissible as long as the company eventually registers the securities. The correct answer is C. The statements are permissible because the offering is exempt from registration and the investors are accredited. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of federal securities laws, specifically the Securities Act of 1933 and the Securities Exchange Act of 1934, and how they apply to different types of offerings and market participants. The core challenge lies in distinguishing between exempt transactions and non-exempt transactions, and understanding the registration requirements and anti-fraud provisions that govern them. Careful judgment is required to ensure compliance and protect investors. The correct approach involves recognizing that the sale of unregistered securities in a private placement, even if to sophisticated investors, is subject to the anti-fraud provisions of the Securities Exchange Act of 1934, while the Securities Act of 1933 provides exemptions from registration for certain private offerings. These exemptions do not shield issuers or their agents from liability for fraudulent misrepresentations or omissions. Therefore, ensuring the accuracy and completeness of all information provided to potential investors, regardless of registration status, is paramount. This aligns with the fundamental principle of investor protection embedded in federal securities law. An incorrect approach would be to assume that, because an offering is conducted as a private placement, and therefore exempt from registration under the Securities Act of 1933, no further disclosure obligations or liabilities exist. This ignores the continuing applicability of Section 10(b) of the Securities Exchange Act of 1934 and Rule 10b-5, which prohibit manipulative and deceptive devices in connection with the purchase or sale of any security. Another incorrect approach would be to focus solely on the registration status of the securities and overlook the potential for misrepresentation or omission of material facts. This demonstrates a misunderstanding of the dual nature of federal securities regulation, which addresses both registration requirements and market conduct. A third incorrect approach would be to believe that the sophistication of the investors negates any disclosure obligation. While investor sophistication is a factor in determining the availability of certain exemptions, it does not eliminate the duty to provide truthful and complete information. Professionals should employ a decision-making framework that prioritizes a thorough understanding of the specific federal securities laws applicable to the transaction. This involves identifying whether an exemption from registration is available, and, if so, ensuring all conditions of that exemption are met. Crucially, it also necessitates a comprehensive assessment of potential liabilities under the anti-fraud provisions, regardless of registration status. This proactive approach, focusing on both compliance and ethical conduct, is essential for navigating the complexities of federal securities regulation and safeguarding investor interests. Question 5. Research into a client's portfolio reveals that a registered representative, while recommending a specific mutual fund, failed to mention that the fund had recently experienced a significant, albeit temporary, decline in its net asset value due to an unusual market event. The representative believes the fund's long-term prospects remain strong, and that the client might be concerned if they knew about the recent dip, potentially leading them to abandon a suitable investment. What is the most appropriate course of action for the registered representative? Option A. Advise the client only if they specifically inquire about the fund's recent performance history. Option B. Omit the information about the recent decline, focusing solely on the fund's historical growth and future potential. Option C. Immediately disclose the recent decline in the mutual fund's net asset value to the client, explaining the circumstances and the representative's continued belief in the fund's long-term suitability. Option D. Proceed with the recommendation, assuming the temporary decline is not material to the client's long-term investment strategy and that the client would likely be overly concerned. The correct answer is C. Immediately disclose the recent decline in the mutual fund's net asset value to the client, explaining the circumstances and the representative's continued belief in the fund's long-term suitability. Explanation. This scenario presents a professional challenge because a registered person is aware of a potential misrepresentation that could mislead investors, impacting their investment decisions. The core ethical and regulatory imperative is to ensure full and fair disclosure to clients. The Series 66 exam emphasizes the importance of acting in the client's best interest and adhering to disclosure rules designed to prevent fraud and deception. The correct approach involves immediately disclosing the material omission to the client. This aligns with the principles of fair dealing and the anti-fraud provisions of securities regulations. Specifically, the Investment Advisors Act of 1940 and state securities laws require investment advisors and their representatives to disclose all material facts that could affect a client's decision. Failing to disclose a known material omission is a violation of these disclosure requirements and constitutes a breach of fiduciary duty. An incorrect approach would be to proceed with the recommendation without informing the client about the omitted information. This is a direct violation of disclosure obligations. By withholding material information, the registered person is allowing the client to make an investment decision based on incomplete and potentially misleading data, which is unethical and illegal. Another incorrect approach is to assume the omission is not material and therefore not reportable. Determination of materiality rests on whether a reasonable investor would consider the information important in making an investment decision. If there is doubt, the prudent and compliant course of action is to disclose. Finally, an incorrect approach would be to only disclose the information if the client specifically asks about it. Disclosure requirements are proactive, not reactive. A registered person has a duty to volunteer material information, not wait to be questioned. This passive approach fails to meet the standard of full and fair disclosure. The professional decision-making process in such situations should involve a clear understanding of disclosure obligations. When a registered person becomes aware of any information that could be material to a client's investment decision, they must assess its significance. If there is any doubt about materiality, or if the information is clearly material, the information must be disclosed to the client promptly and in a manner that is easily understood. This ensures transparency and allows the client to make informed choices, upholding the integrity of the financial advisory profession. Question 6. The evaluation methodology shows that a registered investment advisor representative is tasked with determining the most appropriate method for registering a new public offering of common stock in a state. The issuer is a well-established company with a proven track record of profitability and has already filed a registration statement with the Securities and Exchange Commission for the same offering. The representative needs to select the most efficient and compliant registration process under state securities laws. Option A, registration by coordination. Option B, registration by qualification. Option C, registration by notification. Option D, registration by exemption. The correct answer is A, registration by coordination. Explanation. The evaluation methodology shows that a registered investment advisor representative is considering how to register a new client's securities offering. This scenario is professionally challenging because the representative must accurately identify the most appropriate registration method under the Uniform Securities Act, as adopted by the state, where the offering will be made. Misinterpreting the requirements for coordination, qualification, or notification can lead to significant regulatory violations, including offering unregistered securities, which carries severe penalties for both the issuer and the representative. Careful judgment is required to ensure compliance with state securities laws, which are designed to protect investors. The correct approach involves understanding the specific characteristics of the offering and the issuer to determine the most suitable registration method. Registration by coordination is appropriate for securities already registered with the Securities and Exchange Commission, SEC, under the Securities Act of 1933, provided the state securities administrator has not issued a stop order. Registration by qualification is used for securities not eligible for coordination or notification, requiring a more extensive review by the state administrator. Registration by notification, or filing, is generally for established companies with a history of earnings and is the simplest method, often involving a filing of documents already filed with the SEC. The representative must assess which of these methods aligns with the offering status and the issuer's profile to ensure lawful sale. An incorrect approach would be to assume registration by coordination is always the simplest or fastest method, even if the securities are not registered with the SEC. This ignores the fundamental requirement of prior SEC registration for coordination. Another incorrect approach is to attempt registration by qualification when the offering clearly meets the criteria for registration by notification. This would impose unnecessary burdens and scrutiny on the issuer and the offering potentially delaying the sale and increasing costs without a regulatory benefit. Finally, failing to recognize when an exemption from registration might apply and proceeding with a registration method unnecessarily is also an incorrect approach, as it is inefficient and may not be the most cost-effective or timely solution for the client. Professionals should approach this situation by first identifying the type of security being offered and its registration status with the SEC. Next, they should determine the issuer's financial history and operational characteristics. Based on this information, they can then evaluate the criteria for each registration method: coordination, qualification, and notification. If the securities are SEC registered, coordination is likely. If not, and the issuer has a strong earnings history, notification might be possible. If neither of those apply, qualification becomes the default. Throughout this process, consulting the specific state securities laws and regulations is paramount, as variations can exist. Question 7. Comparative studies suggest that the process of transferring investment advisory contracts can be complex. An investment advisor is considering selling its business to another registered investment advisor. The sale agreement includes the assignment of all existing advisory contracts. Which of the following actions best adheres to the regulatory framework governing such transaction? Option A. Proceed with the assignment of the contracts as part of the sale, and then notify clients of the change. Option B. Obtain written consent from each client prior to the effective date of the assignment. Option C. Assume client consent is implied by the sale of the business and proceed with the assignment without individual client notification. Option D. Inform clients of the sale after the assignment is complete, allowing them to opt out if they choose. Correct answer is A. Proceed with the assignment of the contracts as part of the sale, and then notify clients of the change. Explanation. This scenario presents a professional challenge because the assignment of an investment advisory contract involves a significant transfer of client relationships and responsibilities. Advisors must navigate this transition with utmost integrity, ensuring client interests remain paramount and all regulatory requirements are met. The core of the challenge lies in balancing the business needs of the transferring advisor with the fiduciary duty owed to the clients. The correct approach involves obtaining explicit client consent before assigning the advisory contract. This aligns with the fiduciary duty of an investment advisor, which requires acting in the best interest of the client. Under the Investment Advisors Act of 1940, specifically Rule 205-2, 11, and interpretations thereof, an assignment of an advisory contract is generally considered to occur when there is a change in the principles of the advisory firm or a change in the ownership of the firm that results in a change in the effective control of the business. Crucially, such assignments are typically prohibited without prior client consent. This requirement ensures that clients have the opportunity to review the new advisory arrangement and decide if they wish to continue their relationship with the firm under new management or ownership. Ethical considerations also strongly support this approach, as transparency and client autonomy are fundamental to building and maintaining trust. An incorrect approach would be to assume client consent is implied, or to proceed with the assignment without any notification or opportunity for the client to object. This directly violates the regulatory requirement for client consent and breaches the fiduciary duty. Failing to obtain consent is a clear regulatory violation and an ethical lapse, as it deprives clients of their right to make informed decisions about their financial advisory relationships. Another incorrect approach would be to only notify clients after the assignment has been completed. This is also a violation because the regulation mandates prior consent, not post-assignment notification. This approach undermines the spirit of the rule, which is to give clients control over who manages their assets. Professionals should employ a decision-making framework that prioritizes client interests and regulatory compliance. This involves 1. Identifying potential triggers for contract assignment, e.g., firm sale, merger, change in control. 2. Consulting relevant regulations, e.g., Investment Advisors Act of 1940, state securities laws, to understand specific requirements for assignment. 3. Developing a clear communication plan to inform clients about the proposed assignment. 4. Obtaining written, affirmative consent from each client before the assignment becomes effective. 5. Ensuring all documentation is accurate and retained as per regulatory requirements. This systematic approach ensures that client rights are protected and regulatory obligations are fulfilled. Question 8. The control framework reveals that client, who recently experienced significant losses in their investment portfolio, is threatening to sue their registered representative for negligence and breach of fiduciary duty. The representative believes they acted appropriately and that the losses were due to unforeseen market volatility. Which of the following represents the most prudent course of action to mitigate potential civil liability? Option A. Immediately contact the firm's legal counsel to discuss the situation and gather all relevant documentation pertaining to the client's account and the representative's actions. Option B. Advise the client that investment losses are a normal part of investing and that the representative cannot be held responsible for market fluctuations. Option C. Recommend that the client immediately liquidate all remaining holdings to prevent further potential losses. Regardless of suitability, Option D. Offer to waive all commissions on the client's past transactions as a gesture of goodwill to avoid litigation. Correct answer is A. Immediately contact the firm's legal counsel to discuss the situation and gather all relevant documentation pertaining to the client's account and the representative's actions. Explanation. This scenario is professionally challenging because it requires a registered person to navigate potential civil liability arising from a client's investment losses, which could stem from various causes including market downturns, the client's own risk tolerance, or potentially the registered person's actions or omissions. The registered person must carefully assess their role and responsibilities under the Uniform Combined State Law Examinations regulatory framework, specifically focusing on civil liability provisions. The correct approach involves understanding that civil liability for investment losses typically arises from violations of securities laws, such as fraud, misrepresentation, omission of material facts, or breach of fiduciary duty. A registered person's obligation is to act in the client's best interest, recommend suitable investments, and provide accurate and complete information. If the registered person can demonstrate that their actions were compliant with these obligations, and that the losses were primarily due to market forces or the client's own investment decisions within their stated risk profile, they may have a defense against civil claims. This approach prioritizes adherence to regulatory standards and ethical conduct, which are the primary defenses against civil liability. An incorrect approach would be to ignore the client's concerns or dismiss the possibility of liability without a thorough review. This demonstrates a lack of professional responsibility and could exacerbate the situation, leading to further legal complications and reputational damage. Another incorrect approach would be to admit fault prematurely without a proper investigation, which could create unnecessary liability. Finally, attempting to shift blame entirely to the client, without considering the registered person's own conduct or recommendations, would also be an inappropriate and potentially liable course of action. Professionals should approach such situations by first gathering all relevant documentation, including client agreements, suitability forms, transaction records, and communications. They should then objectively assess their actions and recommendations against the applicable securities laws and regulations. If there is any indication of potential wrongdoing or a breach of duty, seeking legal counsel is paramount. The decision-making process should be guided by a commitment to transparency, accuracy, and the client's best interests, always within the bounds of regulatory compliance. Question 9. Regulatory review indicates that an investment advisor representative has identified a suitable investment opportunity for a client that aligns with their stated financial goals. The representative also realizes that they have a personal financial interest in this particular investment, which is not publicly known. The representative is considering whether to disclose this personal interest to the client before making the recommendation. Option A. Proceed with the recommendation and disclose the personal interest to the client only after the transaction has been completed. Option B. Disclose the personal interest to the client and obtain their written consent before proceeding with the recommendation. Option C. Recommend the investment to the client without disclosing the personal interest, assuming the investment is truly in the client's best interest. Option D. Recommend the investment to the client, but subtly omit any mention of the personal interest, relying on the client's trust. The correct answer is B. Disclose the personal interest to the client and obtain their written consent before proceeding with the recommendation. Explanation. This scenario presents a professional challenge because it requires an investment advisor representative to balance their fiduciary duty to a client with the potential for personal gain, while navigating the complex landscape of prohibited practices under Series 66 regulations. The core of the challenge lies in discerning between legitimate business practices and those that could be construed as fraudulent or unethical, particularly when personal interests are involved. Careful judgment is required to ensure all actions are transparent, fair, and in the client's best interest, adhering strictly to the Investment Advisors Act of 1940 and state securities laws. The correct approach involves immediately disclosing the potential conflict of interest to the client and obtaining their informed consent before proceeding. This aligns with the fiduciary standard, which mandates that investment advisors act solely in the best interest of their clients. Transparency regarding any personal interest in a recommended investment is paramount. Obtaining written consent after full disclosure demonstrates that the client understands the situation and has agreed to the proposed course of action, thereby mitigating the risk of a fraudulent or deceptive practice. This approach directly addresses the potential for undisclosed conflicts and ensures compliance with anti-fraud provisions. An incorrect approach would be to recommend the investment without disclosing the personal stake. This constitutes a fraudulent practice because it misrepresents the advisor's impartiality and fails to provide the client with all material information necessary to make an informed decision. Such an action violates the duty of loyalty and good faith owed to the client, potentially leading to a breach of fiduciary duty and violations of anti-fraud rules. Another incorrect approach would be to proceed with the recommendation, assuming the investment is genuinely beneficial to the client, and only disclosing the personal interest after the transaction is completed. This is still problematic as it deprives the client of the opportunity to consider the conflict of interest before making a decision. The disclosure must be proactive, not reactive, to be truly effective in preventing potential harm and upholding ethical standards. Finally, an incorrect approach would be to subtly steer the client towards the investment without any explicit mention of the personal interest, hoping the client will not discover it. This is a deceptive practice, as it involves intentional omission of material facts to influence the client's decision for personal gain. It directly contravenes the principles of honesty and fair dealing expected of investment professionals. The professional decision-making process for similar situations should involve a clear framework. 1. Identify potential conflicts of interest. Always consider if personal interests could influence recommendations. 2. Prioritize client's best interest. The client's needs and objectives must be the primary consideration. 3. Full and timely disclosure. Any conflict, no matter how minor it may seem, must be disclosed to the client before any action is taken. 4. Obtain informed consent. Ensure the client understands the disclosed conflict and agrees to proceed. 5. Document all communications and decisions. Maintain records of disclosures and client consent. 6. Consult compliance or legal counsel if unsure. When in doubt, seek guidance to ensure adherence to regulations. Question 10. Consider a scenario where a registered investment advisor representative, who is registered in State A, provides personalized investment advice to a client who resides in State B. The investment advisor representative has a vacation home in State B and occasionally meets the client there. The representative has only one client in State B. The representative believes that because they have minimal contact with State B and only one client, they are exempt from registration in State B. What is the most appropriate course of action for the investment advisor representative in this situation? Option A. The investment advisor representative should cease all communication with the client until they can establish a physical office in State B. Option B. The investment advisor representative can continue to provide advice without registering in State B, as they have only one client there and a personal connection to the state. Option C. The investment advisor representative should register as an investment advisor in State B or determine if they qualify as a federal covered investment advisor. Option D. The investment advisor representative should rely on the de minimis exemption for investment advisors, as having only one client in State B exempts them from registration. The correct answer is C. The investment advisor representative should register as an investment advisor in State B or determine if they qualify as a federal covered investment advisor. Explanation: this scenario presents a professional challenge because it requires a nuanced understanding of registration requirements and exemptions under the Uniform Combined State Law Examination, Series 66, framework. The core difficulty lies in distinguishing between activities that necessitate registration and those that may be exempt, particularly when dealing with out-of-state clients, and the nature of the advice provided. A careful assessment of the advisor's actions against the relevant state securities laws is paramount to avoid regulatory violations and potential client harm. The correct approach involves recognizing that providing investment advice, even to a single client in a state where the advisor is not registered, generally triggers registration requirements unless a specific exemption applies. In this case, the advisor is soliciting business and providing personalized investment advice to a client residing in a state where they are not registered. The de minimis exemption for investment advisors typically applies to the number of clients, not the location of the advice or solicitation. Therefore, the advisor must determine if they meet the criteria for registration as an investment advisor in that state, or if another exemption, such as the Federal Covered Investment Advisor exemption, if applicable, is available. Given the facts, the most prudent and compliant action is to seek registration or cease providing advice to the client in that jurisdiction until registration is secured. An incorrect approach would be to assume that because the advisor has fewer than 15 clients in that state, they are exempt. This misinterprets the de minimis exemption, which is often tied to the number of clients within a state, and does not necessarily exempt an advisor from registration if they are actively soliciting business or providing advice in a state where they are not registered, especially if the state's laws have specific provisions regarding out-of-state advisors. Another incorrect approach would be to believe that simply having a physical presence in another state, e.g., a vacation home, negates the need for registration in the client's home state. The location of the client and the provision of advice are the primary determinants of jurisdiction. Finally, assuming that the advice is general and not specific is a dangerous assumption. Investment advice, even if not a full portfolio management service, can be considered specific enough to trigger registration if it is tailored to the client's situation. Professionals should approach such situations by first identifying the client's state of residence. Then, they must consult the relevant state securities laws and the Investment Advisors Act of 1940 to determine registration obligations. This involves understanding the definitions of investment advisor, investment advice, and the various exemptions available at both the state and federal levels. If there is any doubt, the safest and most ethical course of action is to err on the side of caution and seek registration or consult with legal counsel specializing in securities law. A proactive approach to understanding and complying with jurisdictional registration requirements is essential for maintaining ethical standards and avoiding regulatory penalties. Question 11. System analysis indicates that a financial planner who is not registered as an investment advisor in any state provides a friend with detailed recommendations on specific stocks to purchase for their retirement account. The planner explicitly states that they are not charging their friend for this advice and that it is purely a personal favor. The planner's primary business is providing financial planning services for a fee to other clients, but this specific interaction with the friend is outside of that formal client relationship. Which of the following best describes the planner's situation under the Series 66 regulatory framework? Option A. The planner is excluded from the definition of an investment advisor because no fee was charged for the advice to the friend. Option B. The planner is excluded from the definition of an investment advisor because the advice was given to a friend and not a formal client. Option C. The planner is likely considered an investment advisor because the advice provided is specific to securities and not general financial or economic information, regardless of the lack of direct compensation or the informal relationship. Option D. The planner is excluded from the definition of an investment advisor because they are a financial planner and not a broker-dealer. The correct answer is A. The planner is excluded from the definition of an investment advisor because no fee was charged for the advice to the friend. Explanation. This scenario presents a professional challenge because it requires distinguishing between providing general financial information and offering personalized investment advice, a critical distinction under the Uniform Combined State Law Examinations regulatory framework. The challenge lies in the subtle nature of the advice given and the potential for it to be misconstrued as regulated activity, even if unintended. Careful judgment is required to ensure compliance with state securities laws, specifically the definition of an investment advisor and its associated exclusions. The correct approach involves recognizing that the individual's actions, while seemingly helpful, fall outside the statutory exclusions for investment advisors. Specifically, the advice provided is not merely general financial and economic information, but is tailored to a specific client's situation and investment goals, even without direct compensation for that specific advice. This constitutes providing advice regarding securities, which, absent a specific exclusion, necessitates registration as an investment advisor. The regulatory justification is found in the Investment Advisors Act of 1940 and its state-level counterparts, which define an investment advisor broadly and list specific exclusions. The exclusion for publishers of general circulation periodicals is narrowly interpreted and does not cover personalized advice. Similarly, the exclusion for broker-dealers providing incidental advice is tied to their primary business of effecting securities transactions and is not applicable here. An incorrect approach would be to assume that because no direct fee was charged for the specific advice, or because the advice was delivered in a casual setting, it does not constitute investment advisory activity. This fails to recognize that compensation can be indirect, and the nature of the advice itself is the primary determinant. Another incorrect approach would be to rely on the exclusion for advice given by a lawyer, accountant, or engineer solely based on their professional designation, without considering whether the advice is solely incidental to their practice of law, accounting, or engineering. Providing investment advice, even if not the primary service, would still trigger registration requirements if it falls outside the scope of their primary professional duties. The professional decision-making process for similar situations should involve a thorough understanding of the definition of an investment advisor and its exclusions. When in doubt about whether an action constitutes investment advice, professionals should err on the side of caution and consult the relevant state securities administrator or legal counsel. The focus should always be on the substance of the communication and its potential impact on the recipient's investment decisions, rather than solely on the form or the presence or absence of direct compensation. Question 12. The investigation demonstrates that a registered investment advisor received a check from a client intended for investment. The advisor's administrative assistant, without explicit instruction from the principal, deposited the check into the firm's general operating account, intending to transfer it to the appropriate client account the following business day. What is the most appropriate course of action for the registered investment advisor to take immediately upon discovering this situation? Option A. Issue a refund check to the client for the amount received and inform the client that the firm cannot accept funds directly. Option B. Document the deposit in the firm's internal records and proceed with the planned transfer to the client's investment account on the following business day as originally intended. Option C. Immediately transfer the funds from the firm's operating account to a qualified custodian designated for the client's assets and notify the client of the deposit and the temporary holding in the operating account. Option D. Contact the client to explain the administrative error and request written authorization to hold the funds in the firm's operating account for an additional day. The correct answer is C. Immediately transfer the funds from the firm's operating account to a qualified custodian designated for the client's assets and notify the client of the deposit and the temporary holding in the operating account. Explanation. This scenario presents a professional challenge because it requires a financial professional to balance client trust and regulatory compliance when handling client assets. The core issue revolves around the safekeeping of client funds and securities, a fundamental tenet of investor protection under the Securities Exchange Act of 1934 and the Investment Advisors Act of 1940, as interpreted by state securities regulators. The professional must ensure that client assets are segregated and protected from misuse or commingling with the firm's own assets, which is a critical aspect of fiduciary duty. The correct approach involves immediately segregating the client's funds and securities into a separate account that is clearly designated as belonging to the client. This aligns with the regulatory requirement for custodianship, which mandates that client assets be held by a qualified custodian, or if held by the investment advisor, that they be subject to strict safeguards, including prompt delivery to a qualified custodian, notification to the client, and an annual surprise examination by an independent accountant. This approach directly upholds the fiduciary duty owed to the client and adheres to the spirit and letter of regulations designed to prevent fraud and protect investors. An incorrect approach would be to deposit the client's funds into the firm's operating account, even with the intention of transferring them later. This action violates the principle of segregation and creates a risk of commingling, where client assets become indistinguishable from the firm's assets. This is a direct violation of rules prohibiting the misuse of client funds and can lead to severe regulatory penalties, including fines, suspension, or revocation of registration. Another incorrect approach would be to delay the transfer of funds to a qualified custodian, as this prolongs the period of potential risk to the client's assets and fails to meet the prompt delivery requirements stipulated by regulations. Furthermore, failing to provide the client with clear and timely notification about the location and status of their assets is a breach of transparency and a violation of disclosure requirements. The professional decision-making process in such situations should begin with an immediate recognition of the regulatory and ethical obligations concerning client asset custody. The primary consideration must always be the protection of the client's assets. This involves understanding and applying the specific rules regarding qualified custodians, segregation of assets, and notification requirements. When faced with a situation involving client funds or securities, the professional should proactively implement procedures that ensure compliance, such as immediate deposit into a client-specific custodial account or prompt transfer to a qualified custodian, coupled with thorough documentation and client communication. Question 13. The analysis reveals that a registered investment advisor representative is considering using a client's positive feedback in a marketing brochure. The feedback is genuine and reflects the client's satisfaction with the services received. However, the client is a personal friend of the representative and has received a small gift card as a token of appreciation for their long-standing relationship. Though this was not directly tied to providing the testimonial, which of the following actions best adheres to the regulatory framework governing investment advisor communications under the Investment Advisors Act of 1940? Option A. Include the client's feedback in the brochure without any additional disclosures, as the feedback is genuine and the gift was not a direct payment for the testimonial. Option B. Include the client's feedback in the brochure, along with a disclosure stating that the client is a personal friend and received a gift card. Option C. Exclude the client's feedback from the brochure to avoid any potential perception of impropriety, even though the feedback is truthful. Option D. Include the client's feedback in the brochure, but edit it to remove any subjective opinions and focus solely on factual statements about the services. The correct answer is B. Include the client's feedback in the brochure, along with a disclosure stating that the client is a personal friend and received a gift card. Explanation. This scenario presents a professional challenge because it requires a registered investment advisor representative to navigate the nuanced requirements of the Investment Advisors Act of 1940 concerning advertising and communications. The core difficulty lies in distinguishing between permissible factual statements and potentially misleading or exaggerated claims that could violate the Act's anti-fraud provisions. Careful judgment is required to ensure all communications are fair, balanced, and do not create unrealistic expectations for prospective clients. The correct approach involves ensuring that any communication, including testimonials, is presented in a manner that is not misleading and includes necessary disclosures. Specifically, if a testimonial is used, it must be accompanied by a clear and conspicuous disclosure of any compensation paid to the individual providing the testimonial, as well as any material conflicts of interest. This aligns with the Investment Advisors Act of 1940, which prohibits investment advisors from engaging in fraudulent, deceptive, or manipulative practices. The SEC's guidance emphasizes that while testimonials are not per se prohibited, their use must be carefully managed to avoid misleading investors. Disclosing compensation and conflicts of interest is a key regulatory safeguard to ensure transparency and prevent undue influence on potential clients. An incorrect approach would be to use a testimonial without any accompanying disclosures, even if the testimonial itself is factually accurate. This fails to address the potential for the testimonial to be perceived as an endorsement influenced by compensation or other undisclosed relationships, thereby misleading prospective clients about the impartiality of the recommendation. This violates the spirit and letter of the Investment Advisors Act of 1940, which aims to protect investors from deceptive practices. Another incorrect approach would be to present a testimonial that includes subjective opinions or predictions about future performance without any disclaimers. While the testimonial might reflect the individual's genuine experience, The inclusion of performance predictions can be highly misleading, as past performance is not indicative of future results, and such statements could be construed as guarantees or assurances of success. This directly contravenes the regulatory prohibition against making false or misleading statements of fact or opinion. A third incorrect approach would be to selectively edit a testimonial to remove negative aspects, while highlighting only positive comments. This practice distorts the overall sentiment of the testimonial and presents an unbalanced and therefore misleading picture of the advisor's services. The Investment Advisors Act of 1940 requires communications to be fair and balanced, and selective editing undermines this principle by creating a false impression. The professional reasoning framework for such situations should involve a proactive review process for all client communications. Before dissemination, all materials should be assessed for potential misrepresentation, omission of material facts, or exaggeration. This includes considering the perspective of a reasonable investor and whether the communication could lead to an unfounded belief or expectation. When in doubt, err on the side of caution and include additional disclosures, or revise the communication to ensure compliance with the Investment Advisors Act of 1940 and its anti-fraud provisions. Question 14. The evaluation methodology shows that an investment advisor representative IR has a long-standing client who is inquiring about a potential merger between two publicly traded companies. The IAR has recently learned through a confidential conversation with a contact at one of the companies that the merger is highly probable and will likely result in a significant stock price increase for the target company. The client is asking for the IAR's opinion on whether to invest heavily in the target company's stock before the merger is publicly announced. Which of the following represents the most appropriate course of action for the IAR? Option A. Advise the client to invest in the target company's stock, explaining that the information suggests a strong opportunity. Option B. Decline to provide specific investment advice based on the confidential information, and instead discuss investment strategies based on publicly available data and the client's financial goals. Option C. Subtly suggest to the client that investing in the target company's stock might be a good idea without explicitly stating the reason. Option D. Ignore the client's specific question about the target company and proceed to discuss other investment opportunities that are not related to the merger. The correct answer is A. Advise the client to invest in the target company's stock, explaining that the information suggests a strong opportunity. Explanation. This scenario presents a professional challenge because it requires an investment advisor representative IR to balance client needs with regulatory obligations, specifically concerning the disclosure of material non-public information. The IAR must act in the client's best interest while adhering to strict rules against insider trading, which is a cornerstone of fair securities markets. The challenge lies in recognizing the potential for a perceived conflict of interest and navigating it with transparency and integrity. The correct approach involves the IAR declining to share the specific, non-public information about the upcoming merger. This upholds the IAR's fiduciary duty to act in the client's best interest by preventing the client from engaging in potentially illegal and unethical trading activities based on privileged information. Furthermore, it strictly adheres to the anti-fraud provisions of the Investment Advisors Act of 1940 and state securities laws, which prohibit the use of material non-public information for personal gain or to advise others. The IAR's responsibility is to provide advice based on publicly available information and sound investment principles, not insider tips. An incorrect approach would be to share the information with the client, even if the client is a long-standing and valued customer. This action directly violates the prohibition against insider trading. It would expose both the IAR and the client to severe legal penalties, including fines and imprisonment, and would result in the IAR's likely revocation of their registration. Another incorrect approach would be to subtly hint at the information without explicitly stating it. This is still a form of passing on material non-public information and is ethically dubious and legally risky, as regulators can infer intent and action from indirect communication. It fails to provide clear guidance and instead creates ambiguity that could lead to improper trading. A third incorrect approach would be to ignore the client's request and proceed with other investment recommendations without addressing the core of the client's inquiry. While this avoids sharing the insider information, it fails to educate the client on why such information cannot be shared and could damage the client relationship, without reinforcing ethical and legal boundaries. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. When faced with a request that could involve material non-public information, the IAR should first identify the nature of the information. If it is indeed material and non-public, the IAR must immediately recognize the prohibition against its dissemination. The next step is to politely but firmly decline the request, explaining that such information cannot be shared due to regulatory restrictions and ethical obligations. The IAR should then pivot to discussing investment strategies based on publicly available data and the client's established financial goals and risk tolerance. This approach reinforces the IAR's commitment to lawful and ethical practice while maintaining a professional and informative client relationship. Question 15. To address the challenge of an investment advisor needing to terminate an advisory contract with a client due to the advisor's decision to cease operations, which of the following actions best upholds the advisor's regulatory and ethical obligations? Option A. Retain the full advisory fee for the contract period, as the contract was in force for that duration, and inform the client that no services will be provided going forward. Option B. Send a notification of termination to the client only after all client accounts have been transferred to another firm, without specifying the exact date of fee adjustment. Option C. Inform the client verbally about the termination and assure them that any fee adjustments will be handled at the end of the contract year. Option D. Immediately notify the client in writing of the termination, specifying the effective date, and promptly calculate and return any unearned advisory fees on a pro rata basis. The correct answer is D. Immediately notify the client in writing of the termination, specifying the effective date, and promptly calculate and return any unearned advisory fees on a pro rata basis. Explanation. This scenario presents a professional challenge because an investment advisor must navigate the termination of an advisory contract while adhering strictly to the Uniform Securities Act and its associated rules, particularly concerning client notification and the return of unearned fees. The advisor's duty of care and fiduciary responsibility are paramount, requiring prompt and transparent action. Failure to comply can result in regulatory sanctions, reputational damage, and potential legal action. The correct approach involves promptly notifying the client of the termination, clearly stating the effective date, and calculating and returning any unearned advisory fees on a pro rata basis. This aligns with the fiduciary duty owed to the client and the regulatory requirements for contract termination under the Uniform Securities Act, which emphasizes fair dealing and the protection of investors. Specifically, Rule 205-1 under the Investment Advisors Act of 1940, which is incorporated by reference in many state regulations for Series 66 purposes, generally prohibits performance-based fees unless specific conditions are met. And while this question doesn't involve performance fees, the principle of fair fee calculation and return upon termination is a core tenet of advisory conduct. State regulations often mirror these federal principles, requiring prompt return of unearned compensation. An incorrect approach would be to delay notification or the return of unearned fees, hoping the client might forget or overlook the matter. This constitutes a breach of fiduciary duty and violates the spirit and letter of securities regulations that mandate prompt and fair dealing. Another incorrect approach is to retain the full fee for the contract period, even if services were not rendered for the entire duration. This is a direct violation of the requirement to return unearned compensation and is considered unethical and illegal. Finally, failing to provide a clear and itemized statement of services rendered and fees earned, especially when a refund is due, can be seen as an attempt to obscure the client's rights and is also a regulatory failure. Professionals should approach such situations by prioritizing client interests and regulatory compliance. A clear written policy for contract termination, including a standardized process for fee calculation and refund, is essential. Upon initiating termination, the advisor should immediately consult the advisory contract and relevant regulations, draft a clear notification letter, and process the fee refund without delay. This systematic approach ensures adherence to legal and ethical standards and reinforces client trust. Question 16. The review process indicates that a registered investment advisor representative has recently been subject to a cease and desist order from a state securities administrator due to allegations of fraudulent activity. Which of the following actions is the most appropriate and legally compliant response for the representative? Option A. Immediately file an amendment to their Form U-4 disclosing the cease and desist order and cooperate fully with any subsequent inquiries from regulatory bodies. Option B. Only disclose the cease and desist order if it results in a formal suspension or revocation of their registration. Option C. Wait to see if the state securities administrator takes further action before reporting the order, as it may be resolved internally. Option D. Inform their employing firm of the order, but refrain from filing any amendments to their personal registration forms until formally requested by a regulator. Correct answer is A. Immediately file an amendment to their Form U-4 disclosing the cease and desist order and cooperate fully with any subsequent inquiries from regulatory bodies. Explanation: the review process indicates a potential violation of registration requirements, specifically concerning the denial, suspension, or revocation of a registered person's license. This scenario is professionally challenging because it requires a thorough understanding of the Securities Act of 1933, the Securities Exchange Act of 1934, and the Investment Advisors Act of 1940, as well as the rules and regulations promulgated by the Securities and Exchange Commission, SEC, and state securities administrators. A registered person's livelihood and the public's trust are at stake, necessitating a careful and legally compliant response. The correct approach involves promptly and accurately reporting any adverse regulatory actions to the appropriate regulatory bodies, specifically the SEC and any relevant state securities administrators, through the required filings, such as Form U-4 amendments. This is mandated by federal and state securities laws, which require registered persons and investment advisors to disclose material facts and any disciplinary actions taken against them. Failure to do so can lead to further penalties, including more severe disciplinary actions and potential criminal charges. This proactive and transparent reporting upholds the integrity of the securities markets and protects investors. An incorrect approach would be to delay or omit reporting the adverse regulatory action. This failure to disclose material information is a direct violation of federal and state securities laws and regulations. It demonstrates a lack of candor and can be interpreted as an attempt to conceal information from regulators and the investing public, thereby undermining the regulatory framework designed to ensure fair and honest markets. Another incorrect approach would be to misrepresent the nature or severity of the adverse action. This misrepresentation constitutes a separate violation and further erodes the trust placed in registered persons. Providing incomplete or misleading information is as detrimental as outright omission. Professionals should approach such situations by first understanding the specific reporting obligations triggered by the adverse action. This involves consulting the relevant rules and regulations and seeking legal counsel if necessary. The decision-making process should prioritize full and truthful disclosure, adhering strictly to the timelines and procedures outlined by the SEC and state securities administrators. Transparency and compliance are paramount in maintaining registration and professional standing. Question 17. What factors determine whether a statement made by an investment advisor representative regarding potential future investment performance is considered misleading under the Uniform Combined State Law Examinations regulatory framework? Option A. The presence of reasonable assumptions and disclosures of uncertainty regarding future outcomes, alongside a balanced presentation of potential risks and rewards. Option B. The inclusion of hypothetical performance scenarios that are presented as likely future results without explicit disclaimers. Option C. The use of optimistic language to describe the investment's potential without any supporting data or analysis. Option D. The emphasis on past performance trends as a direct predictor of future investment success without acknowledging inherent market volatility. The correct answer is A. The presence of reasonable assumptions and disclosures of uncertainty regarding future outcomes, alongside a balanced presentation of potential risks and rewards. Explanation: this scenario presents a professional challenge because it requires an investment advisor representative to distinguish between legitimate, forward-looking statements about potential future performance and statements that are misleading and could induce an investor to make a decision based on false or exaggerated pretenses. The core difficulty lies in the subjective nature of projections and the fine line between optimistic forecasting and outright misrepresentation. Careful judgment is required to ensure all communications are fair, balanced, and not likely to mislead. The correct approach involves evaluating the statement based on whether it presents a reasonable expectation of future results, supported by objective data, or a clear disclaimer of uncertainty, and whether it omits material facts that would alter the overall impression. This aligns with the anti-fraud provisions of the Securities Act of 1933 and the Securities Exchange Act of 1934, as well as state securities laws that prohibit untrue statements of material fact or omissions of material fact that render statements misleading. Specifically, Rule 10b-5 under the Securities Exchange Act of 1934 makes it unlawful to make any untrue statement of a material fact or to omit to state a material fact necessary in order to make the statements made, in the light of the circumstances under which they were made, not misleading. A statement that is merely optimistic but grounded in reasonable assumptions and accompanied by appropriate risk disclosures is generally permissible. An incorrect approach would be to present hypothetical future performance as a guaranteed outcome without any qualification. This is a regulatory and ethical failure because it violates the principle of providing accurate and complete information. Such a statement is misleading as it creates an unrealistic expectation of returns, potentially leading investors to make investment decisions they would not otherwise make. This directly contravenes the requirement to avoid fraudulent, deceptive, or manipulative practices. Another incorrect approach is to focus solely on past performance as indicative of future results without acknowledging that past performance is not a guarantee of future success. While past performance can be a factor in investment analysis, presenting it as a predictor of future outcomes without context or caveats is misleading. Regulatory bodies consistently warn against this practice, emphasizing that all investment recommendations must be accompanied by disclosures about the inherent risks and the possibility of loss. A third incorrect approach is to make broad, unsubstantiated claims about the certainty of investment success, without any basis in fact or reasonable projection. This is misleading because it lacks any objective support and creates a false sense of security for the investor. It fails to meet the standard of care expected of investment professionals, who are obligated to provide advice that is suitable and based on sound analysis, not mere speculation or hyperbole. The professional decision-making process for similar situations should involve a rigorous assessment of any statement about future performance. This includes asking, is this statement based on reasonable assumptions? Are the risks clearly disclosed? Is there any omission of material fact that would make the statement misleading? Is this statement fair and balanced, or does it create an overly optimistic or guaranteed impression? If there is any doubt, err on the side of caution and provide more disclosure and context. Question 18. Benchmark analysis indicates that a registered investment advisor is considering assisting a startup company in raising capital through a private placement. The company intends to offer its securities exclusively to a group of 10 individuals, all of whom are founders' friends and business associates. The company states that these individuals are all highly experienced in business and finance and have previously invested in private companies. The advisor has been provided with a list of these individuals and their general professional backgrounds. The company wishes to avoid the expense and complexity of registering the securities. Which of the following actions by the investment advisor best aligns with regulatory requirements for exemptions from registration? Option A. Suggests that the company can proceed with the offering without registration by simply obtaining a signed statement from each individual confirming their sophistication and accredited status. Option B. Proceed with assisting the private placement, relying on the fact that the offering is limited to a small, sophisticated group of individuals and therefore likely exempt. Option C. Recommend that the company proceed with the offering without registration, as the individuals are friends and associates of the founders, implying a pre-existing relationship that bypasses registration needs. Option D. Advise the company that a private placement to this group may qualify for an exemption under Regulation D, Rule 506, provided that the company ensures all purchasers are accredited investors and provides them with adequate disclosure documents, and that no general solicitation is used. The correct answer is B. Proceed with assisting the private placement, relying on the fact that the offering is limited to a small, sophisticated group of individuals and therefore likely exempt. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of the exemptions available under the Securities Act of 1933 and state securities laws, specifically regarding private placements. The advisor must accurately assess whether a proposed transaction qualifies for an exemption to avoid engaging in unregistered, non-exempt securities offerings, which carries significant legal and ethical ramifications. The core difficulty lies in interpreting the conditions of the exemption, particularly the sophistication and number of offerees, and ensuring compliance with anti-fraud provisions. The correct approach involves a thorough review of the facts against the criteria for a Regulation D, Rule 506 offering. This includes verifying that the issuer is not an investment company, that no general solicitation or advertising is used, and that all purchasers are either accredited investors or sophisticated non-accredited investors who receive adequate disclosure. The advisor must also ensure that the issuer takes reasonable steps to verify the accredited status of purchasers. This meticulous adherence to the exemption's requirements is mandated by federal and state securities regulations to protect investors and maintain market integrity. An incorrect approach would be to assume that because the offering is limited to a small number of individuals, it is automatically exempt. This fails to consider the definition of accredited investor or the prohibition against general solicitation. Another incorrect approach is to rely solely on the issuer's representation that the investors are sophisticated without conducting any independent verification or ensuring adequate disclosure documents are provided. This overlooks the advisor's fiduciary duty and the regulatory requirement for due diligence. A further incorrect approach is to proceed with the offering based on a vague understanding of private placement, without confirming it meets the specific conditions of a recognized exemption like Regulation D. This demonstrates a lack of diligence and a disregard for the registration requirements. Professionals should approach such situations by first identifying the specific exemption being considered. Then, they must meticulously cross-reference the facts of the proposed offering against each condition of that exemption. If any condition is not met, the offering is likely not exempt and registration is required. Furthermore, professionals must always be mindful of the anti-fraud provisions, which apply regardless of whether an exemption exists. When in doubt, seeking legal counsel or refusing to participate in a potentially non-compliant offering is the most prudent course of action. Question 19. Quality control measures reveal that a registered investment advisor's marketing department has created a new brochure highlighting the firm's award-winning investment strategies and including a testimonial from a satisfied client about their impressive gains. The brochure does not include any specific performance data or disclaimers about the possibility of investment losses. Which of the following represents the most appropriate risk mitigation approach for the firm's compliance department? Option A. Immediately approve the brochure for distribution, as the use of awards and client testimonials is a common and effective marketing practice. Option B. Advise the marketing department to remove the testimonial, as client testimonials are generally prohibited in investment advertising. Option C. Conduct a thorough review of the brochure to ensure that all claims, including the award's legitimacy and the testimonial's compliance with disclosure rules, are accurate and not misleading, and that appropriate disclaimers regarding investment risk are included. Option D. Approve the brochure, but instruct the marketing department to add a general disclaimer at the end, stating that past performance is not indicative of future results. The correct answer is A. Immediately approve the brochure for distribution, as the use of awards and client testimonials is a common and effective marketing practice. Explanation: this scenario presents a professional challenge because it requires a financial professional to balance the desire to attract new clients with the stringent advertising regulations designed to protect investors. The core of the challenge lies in ensuring that marketing materials are not misleading, even when attempting to highlight positive performance or unique selling propositions. Careful judgment is required to interpret the nuances of advertising rules and apply them to real-world marketing efforts. The correct approach involves proactively reviewing and approving all advertising and marketing communications to ensure compliance with the Securities and Exchange Commission (SEC) and North American Securities Administrators Association (NASA) guidelines, as interpreted by state securities laws. This means verifying that any claims made are accurate, not exaggerated, and do not omit material facts that could mislead an investor. Specifically, this includes ensuring that past performance is presented fairly, with appropriate disclaimers about future results, and that any testimonials or endorsements are disclosed properly. This approach is correct because it directly addresses the regulatory requirement for supervision and compliance in advertising, preventing potential violations before they occur. An incorrect approach would be to assume that a third-party vendor's marketing materials are automatically compliant. This fails to acknowledge the firm's ultimate responsibility for the content of its advertisements. Regulatory frameworks place the onus on the firm and its associated persons to ensure all communications are truthful and not misleading. Another incorrect approach is to rely solely on the absence of explicit prohibitions for certain types of claims. The spirit of advertising regulations goes beyond mere prohibition. It mandates fairness and accuracy. Making claims that are not demonstrably true or that create an unrealistic expectation of returns, even if not explicitly forbidden, can still be considered misleading and a violation. Finally, an incorrect approach is to approve marketing materials based on their popularity or the perceived effectiveness of the message without a thorough review for regulatory compliance. While marketing effectiveness is important, it cannot supersede the legal and ethical obligations to provide accurate and non-misleading information to potential investors. The professional decision-making process for similar situations should involve a systematic review of all marketing materials. This process should include 1. Understanding the specific regulatory requirements for advertising in the relevant jurisdiction. 2. Evaluating the content of the material for accuracy, completeness, and potential for misinterpretation. 3. Ensuring that all necessary disclaimers and disclosures are present and prominent. 4. Documenting the review and approval process. 5. Staying updated on changes in advertising regulations and guidance. Question 20. Risk assessment procedures indicate that a client is interested in purchasing shares of a newly formed company that operates exclusively within the state where the client resides. The company's management claims that because the offering is limited to residents of this single state, and the company's principal place of business is also in this state, the shares are exempt from federal registration requirements and do not need to be registered at the state level. Financial professional is considering facilitating this transaction. Which of the following actions best aligns with the regulatory framework for the Series 66 exam? Option A. Conduct independent due diligence to confirm that all conditions of the intrastate offering exemption, including the residency of all purchasers and the issuer's principal business operations and revenue derivation, are strictly met before facilitating the transaction. Option B. Recommend that the company seek a formal no-action letter from the SEC and the state securities regulator to confirm the exemption, as this is the safest course of action. Option C. Proceed with the transaction, as the described offering appears to meet the criteria for the intrastate offering exemption under the Securities Act of 1933 and state blue sky laws. Option D. Advise the client that the offering is likely exempt and proceed with the transaction, relying on the company's management's assertion of exemption. The correct answer is C. Proceed with the transaction, as the described offering appears to meet the criteria for the intrastate offering exemption under the Securities Act of 1933 and state blue sky laws. Explanation: this scenario is professionally challenging because it requires a financial professional to distinguish between securities that are subject to registration requirements and those that are exempt, a critical aspect of Series 66 compliance. Misidentifying an exempt security can lead to significant regulatory violations, including offering unregistered securities, which carries severe penalties for both the individual and the firm. The professional must exercise careful judgment to ensure all transactions adhere to the Securities Act of 1933 and relevant state securities laws, blue sky laws, as interpreted by the Series 66 exam. The correct approach involves a thorough understanding of the specific exemptions under the Securities Act of 1933 and state laws. This means verifying that the security in question meets all the criteria for a particular exemption, such as the intrastate offering exemption or certain private placement exemptions. The justification for this approach lies in the fundamental principle of investor protection, which is the bedrock of securities regulation. By ensuring that only exempt securities are offered without registration, professionals uphold their duty to comply with the law and prevent investors from being exposed to unregistered and potentially riskier offerings. An incorrect approach would be to assume a security is exempt based solely on the issuer's reputation or the perceived sophistication of the investors. This is a regulatory failure because exemptions are narrowly construed and require strict adherence to their specific conditions. For instance, assuming an intrastate offering is exempt without confirming that all offerees and purchasers are residents of the same state, and that the issuer derives a substantial portion of its revenue from that state, is a violation. Similarly, assuming a security is exempt because it's a private placement without verifying that the offering complies with Regulation D, including limitations on the number of purchasers and the absence of general solicitation, is also a failure. Another incorrect approach is to rely on a verbal assurance from the issuer that the security is exempt without independent verification. This demonstrates a lack of due diligence and a failure to meet the professional standard of care. The professional decision-making process for similar situations should involve a systematic review of the security's characteristics against the known exemptions. This includes 1. Identifying the potential exemption being claimed. 2. Verifying that all conditions and limitations of that specific exemption are met. 3. Documenting the basis for the exemption. 4. Consulting with legal counsel or compliance officers if there is any ambiguity. This structured approach ensures that regulatory requirements are met and investor interests are protected.